All right, good morning, everybody. Welcome to today's webinar. Gary's here from the forwarders list. Today's session is starting the litigation channel from the ground floor. We are lucky to have three esteemed panelists to walk us through here. Dave Parkin, the CEO of Convoke, Mike DeVario, founder and head coach of DeVario Coaching and Consulting, and Michael Stillman, owner of Stillman Law Firm. They're going to kind of walk us through what litigation looks like in today's world, and specifically if you were contemplating starting a litigation program in particular, we think this will be useful. So Mike D is going to start us off, and we are ready to go. So take it away, Mike.
All right. Hey, welcome, everyone. Thank you for joining, and thanks, Gary, for hosting this. It's a pleasure to be here. In case you're wondering, I'm calling in from Columbus, Ohio. We're still experiencing a Midwest winter here. It's 37 degrees, but winter's still going strong here. So I have about 10 minutes, so I'm going to jump right in. But before I do that, I just want to give you a little bit of a perspective from where I'm coming from. You know, I've spent a lot of time in the consumer finance industry, really going back to the 1980s. And all but one of those years was in collections. Many roles in different types of collection functions, whether it was technology, process, operations. And the reason I say that to you is, I think I have a good depth of understanding how it pertains to litigation strategies. But I need to be very clear. My perspective is that I don't take a position for you whether this is a good strategy or not. And because it's so important that you understand that the right strategy for you depends upon many, many variables within your organization. I'm going to view a lot of these variables today, and I will be hitting many of those. And it's going to give you a chance to really kind of internalize your thinking and your thoughts as to how these variables apply with your firm. And I'll move through these quickly. So where do we start? So let's look at this slide. My first point to you is this. If you're going to do a litigation strategy, you really need to build a strong cross-functional team. This slide is a good starting point of what that cross-functional team might look like. So let's go through each bullet. The first bullet is senior leadership, right? And what we're talking about there really is your executive management committee and your CEO. And you're going to need to build a strong commitment from them to move forward. So how do you do that? How do you get senior leadership's commitment for a strategy like this? To me, it's relatively, it's simple to say, but it takes time. You have to build a solid business case in the items that they need to know and understand. The business case should spell out exactly why the liquidation channel makes sense. So let's talk about some of those specifics. The first thing that the leadership team needs to understand is how will moving forward with the litigation channel impact, one of the main concerns, which is revenue. No matter what organization you're in, you have to project revenue either for the year or 2 years or at some period. So how does that work? So when we're in collections, you really only have so many options, right? You can place accounts with your internal group, your collection agencies, your law firms. You can sell debt, or you can do nothing at all. Any of those strategies can work. But let's say you're selling debt. So what happens? So you're generating this much revenue from debt sales right now. You implement a litigation strategy. There can be, depending upon how you roll it out, there can be at least a moderate to significant drop in that revenue as you build out month by month that litigation channel through monthly placements or however you make those placements. At some point, they will equal and maybe even surpass, but it takes time. And I think senior leadership needs to understand that dynamic. Likewise, as it pertains to collection expenses, when you look at debt sales, it has probably the smallest unit cost per dollar collected of any channel that you can work. The cost per dollar collected going with litigation is much higher, actually multiples of that. And you're betting that in the long run that, the yield's going to surpass that of what you're paying or what you're receiving from debt sales. But again, the organization just needs to understand those dynamics. So that's why it's important that, this is all part of the business case. Other areas in the business case, understanding risk versus reward. What is the risk tolerance in your organization? As an example, if you're keeping accounts and currently working those in-house right now, I mean, there's, a modest risk with that. But if you're moving to a litigation challenge or a strategy, you may be challenged even greater from a compliance risk. Where does your leadership stand with that? Do they even understand it? Another aspect would be your cross-functional support. And I touched on that, but this is really important. I mean, I think the leadership needs to understand the total commitment that this is an organizational process. The collections and operations area are typically the ones that come up with the idea and maybe even champion the strategy, but it requires a broad support from so many different areas. And then I think you need to understand, and leadership needs to understand how your footprint plays into the business case or into the strategy. Are you a regional lender or are you a national lender? If you're a regional lender, for example, what are the collection remedies allowed by law within the states that you operate in? Are they states that allow for a wide range of remedies or not? Also, if you're a regional, you may elect to work with a handful of attorneys directly, because it's something you can manage. Versus on a national basis, you may elect to use a forwarder. A forwarder being a firm that already has all the attorneys set up and you place with them, and then they push it on to their attorney network. So in the business case, also, I guess the final piece of this business case, at least for today, is all of the need for the staffing, and that leadership understands that you may not have all the skill sets you need, and you're going to need to buy some industry experience. You're also going to have to build out some support functions, things to handle, people to handle invoicing, liaison work, payment files, documentation. That's just to name a few. And all of these things are going to cost money. And so all of these things should be laid out in that business case. So that really does it for that first bullet point. I mean, the first piece is getting that commitment, and you do that through a solid business case. But let's just take a look at some of these other areas, because they're important as well. You're going to need to lean heavily on your internal legal support or your internal counsel. Now, some of you may outsource that work, but the bottom line is you're going to need some attorneys to understand what the right questions are to ask. You're going to need attorneys to review your legal, your policies and your procedures to, that you establish internal. There's going to be contractual oversight, boarding requirements, due diligence. And there's also going to be, you don't need these attorneys just to start with. You need them throughout the process indefinitely. And I would say something about your legal counsel. They need to be stable. This is not an area where you can have a lot of turnover, because you need your attorneys to become very familiar with both your internal processes and even the attorneys that you're outsourcing to. The next bullet is technology support. And, when I think about that, I think, first off, do you have an inventory management system? Are you going to build one? Are you going to buy one? Whatever you decide, I mean, that's a decision that takes time. You're going to need to, certainly work through all the data security elements of passing sensitive data back and forth between you and your attorneys. And this may be the biggest single most important factor of, anything I talk about today. You'll have other firm-wide systems from a technology standpoint that may need to be integrated with your inventory management system. You're going to be passing data, data back and forth, account level data to and from your attorney. So those processes are going to need to be established. You're going to be moving documents as well, related media. That's something Convoke can help you with. But the good news on the technology side, many of the existing systems that you have right now probably will work with the litigation process, especially if you're placing with collection agencies right now. The next bullet point is operational support. It's really, in most cases, is the collections department. And this is really where the rubber meets the road. This is the attorney selection process. There's a lot of considerations here when you go to select attorneys. The first is, do you build a network yourself, or do you use a forwarder? And there's many, many questions, and there's not a right or wrong answer there. It just depends. It depends upon your situation. Your time to market. Are you regional? Or do you need a national presence? Your willingness to invest in the infrastructure. You could use a hybrid of both to develop a competitive model, where there may be specialty placements or certain product types, that may be better suited for one versus the other. Also, there's going to be an account selection process. All the variables at the account level that you're going to look at to determine what are the right accounts to place in a litigation channel. There's also going to be scrubs, right? You're going to have to scrub out certain accounts. Then there's the whole performance side that the operations or collection area will need to work through. And this is the performance managers, the ones that are reviewing batch level reports, liquidation reports, walking hand in hand with the attorneys. In addition, there's going to be procedure guidelines and SLAs from the client to the firm, on how quickly the attorneys get to specific steps in the litigation process. These could be standard operating procedures, a playbook, a manual. And then you're also going to need to provide guidance to the attorneys on specific account situations, debt settlement accounts, disputes, deceased, debt validation, complaints, etc. The next bullet is data and analytical support. Again, they'll support, from an analytical standpoint, they can support the account selection process, scorecard deployment, and assist with the ongoing performance. And then we have, which is huge, the compliance and audit areas. And this is a broad range of activity, including, licensing, insurances, audits, call monitoring. And you're not just auditing the attorneys, you're also auditing the internal processes that you're using to manage the attorneys. And then finally, lastly, we have the finance department. And you'll need processes to establish, for transmission of funds, and that you'll create and maintain. And most important is you're going to need to project revenues and collections expenses, collection fees, court costs. And this can get very, very complicated. And there's also always a sense of urgency around this, and the accuracy will be critical. And the other thing about it is a lot of times you're going to be dealing with some, accounting rules. So, this is going to be an important piece. And the last piece under, the finance department, hopefully they will provide some financial assessments of your law firms, to ensure that, the respective firms are in a healthy financial situation. You want to stay ahead of that because, the last thing you want to deal with is an attorney that's in Chapter 11 or worse, Chapter 7. So that's really it, guys. That's a lot of it. I covered a lot there in a very short amount of time. But I guess my final three thoughts are this. You need a strong business case and total commitment from your senior leadership. They need to understand the implications of revenue, expenses, and the compliant processes. Secondly, you need that cross-functional work group. The operations and collections area cannot go it alone. And thirdly, and in my opinion, I don't think this is something you can dabble in. It isn't something you just put one toe in. The cost of entry and the expense and the extensiveness of building this out, it's a lot. So I think you're either in or you're not. So with that, I will say, hey, thank you very much. Appreciate it.
So hello, and thank you, Mike. Always good to hear Mike's perspective. I think there's definitely going to be a little bit of overlap from what Mike had to say to what I'm going to say, because at the end of the day, the agendas are similar. Brief introduction to me. I've been practicing law for 33 years, which sounds like it's a lifetime, but actually I've also been married for the same amount of time, which seems like even more of a lifetime. So go figure. During those 33 years, I've been completely immersed in the debt collection world. It's been my practice from the day I got out of law school through today. Started my own practice in '94. We've focused exclusively on debt collections. We operate in 7 states today. I'm personally licensed in 3 states, as well as the District of Columbia. And in addition to litigating in 7 states and the District of Columbia, my office also does some nationwide call and collect and represents several clients through that process across the country. So as far as a litigation channel, like Mike said, right, it's something that you got to be all in. To quote a quote that's often attributable to Yankee legend turned manager Yogi Berra, although we're not sure he actually said it, it ain't over till it's over. And I kind of look at this as being kind of the mantra from this, because you can't really expect that you're going to maximize every last dollar if you leave a litigation strategy on the table, or off the table rather, and you don't pursue it. It's not to say that you're not going to find profit in other ways, but if you're not going to be selling that debt and you are going to be continuing to try to collect on it, then you're never going to be able to maximize those dollars recovered without looking at a litigation strategy. Because at the end of the day, there are just some people who are never going to pay until they're forced to pay. So, beginning considerations, of course, is how you're going to push out a legal network if that's the decision. So are you going to go direct to attorneys versus network? And let me say this, that from my perspective, I work under both. So I work with some clients who use direct to attorney litigation networks, and other clients who have made the decision to go through some sort of a legal network. I'm not advocating for either one. I believe that there's a variety of reasons that either one might be something that is that is just more attractive to a particular creditor or client who is looking to push out a legal network. We'll try to talk through some of those right now, but I think that there are situations where one system is going to be better than the other for one creditor, and then vice versa for another one. Certainly, a lot of the considerations will be centered around the ability to sustain an internal program where you're going direct to attorneys instead of going through some sort of a network. So that comes up with cost considerations. There's no question that it's going to cost you more money to set up your very own network and start to go through direct to attorneys in that process. Having said that, you're going to have a closer relationship in those situations with your legal counsel. And I guess it depends in part on the complexity of the work that you have and what sort of security requirements you may have, et cetera. Typically larger clients that have a nationwide footprint have the ability to be able to manage the infrastructure and to go direct. And for them, that may be advantageous, but there's also some larger clients that have chosen to go through some of the legal networks. So once again, it all depends. For a smaller client, oftentimes, especially if it may be geographic in nature, perhaps regional, or if a client just wants to push out a legal network in a few states because they see those states as being somewhere where they want to start, that also may make sense. And at the end of the day, it may also make sense that a creditor or client may choose to use both and to do some sort of champion challenger and to see what works better. You get into some places, it may be hard to find an attorney to do your work in Montana or Nebraska or some of those other places. So next, you got to look at the data protocols. There are some data protocols that are available out there. Every creditor has to decide whether or not those data protocols that are what I'll kind of call available in the marketplace are secure enough for you. May or may not be. You may choose to go with your own homegrown data protocol. We have clients across the board. We have clients that use a particular vendor that allows them to kind of standardize things. And then we have those that use some other options, and others that just create their very own. The onboarding process can be daunting if you look at that process from a standpoint of what sort of requirements you're going to have, what sort of due diligence you're going to put the vendor through, whether it's a law firm or a network. If you're going to go through a network, that network is likely going to be able to provide you with some pretty good assistance in terms of onboarding, because they've already onboarded a lot of the lawyers in the places where you're going to be looking. So they're going to minimize some of those requirements that you may otherwise need to do yourself. But that can vary significantly from client to client. And at the end of the day, it all depends on what sort of capabilities you have internally. Next, you're going to look at firm requirements, and what are you looking at? Do you want a firm that is nationwide? You want a firm that is one state? You want 50 firms throughout the country? You want 20 firms that might be regional or geographic? There are, once again, pros and cons to each. It's tough to manage 20 states, but there are firms that do a decent job at it. But it's also tough to manage 50 firms. So that's something you really have to decide, and what seems to be kind of the sweet spot is perhaps to find a set number of firms that are regional in nature, that you can minimize the total number of firms, but not necessarily have one firm that handles everything, because there is some historical issues with that, which would suggest that it's perhaps not the best method to use. You also have insurance requirements. Can a smaller firm sustain whatever insurance requirements you may have? Can they provide you with all the necessary policies and procedures that they have, so that you can be satisfied that they're able to look at, to satisfy and service your needs? So next, after you get through all those early considerations, you got to look at account selections, dollar thresholds. I mean, we have some clients that will send $500 accounts out for collections. Does it make sense? It might make sense in one state, such as, for instance, Maryland, where I know we practice and costs are very low. Try to litigate a $500 account in California. Forget about it. The costs are astronomical. A lot more requirements in a state like California, which goes into our geographic considerations. There are some states that are very easy to practice in, that are very friendly and favorable to creditors. And there are others that can be very unfavorable, which would in turn lead to some costs of litigation. Those are the same things that we talked about, right? Court costs to file suit in a place like Maryland, real cheap. Place like California, super expensive, and can definitely impact your ability to be profitable. So next,
Hey, Michael,
yep.
Yeah, just to chime in on that. I mean, we've seen clients be strategic about where they start, right? So they might pick 4 or 5 states that are less expensive on the court cost side, run that out. When they start bringing in money on the collections in 6 months or a year, they add the next batch of states, right? So California is the most expensive in the country. So, some people save the more expensive till they build up some revenue from the easier states to navigate.
Yep. Yeah, absolutely. Definitely things to consider. So if we look over at the next slide, move past account selection, and we're going to look at work standards. So, you want to make sure, whether it's a network or direct to firms, you want to make sure that they have appropriate work standards in place. The first thing is, are you going to sue or not sue? Are you going to leave that up to the firm? Are you going to have certain input into that? There's all kinds of reasons. It could be balance thresholds. It could be decisions based around, hardship claims, claims, threats of counterclaims, etc. Then you look at the litigation process. Today, at the end of the day, I think we really, whether it's a network or a firm, you're going to be looking at a situation where we are in the information business, right? We are passing data. That, at the end of the day, while I'm, out there practicing law and I've got lawyers in the trenches, it's all about the data we're getting back and forth to you. And what happens through that litigation process, we have to make sure that we have processes that are automated and that are put in place not only to protect us, but to protect you as well, and anyone else, including the consumer. I apologize. Can you hear that in the background? Is that okay? I got some work being done in my house. Apologize. Next is post-judgment. So you want to make sure, whether you're going direct or you're going through a network, that post-judgment processes are key, because that is where you're going to see your largest recovery through the legal channel. Post-judgment is extremely important. Every state has different post-judgment remedies. The typical ones are employment garnishments, bank garnishments. There are some others. You want to make sure that whatever methodology you choose, they are maximizing post-judgment. Last, settlement posture. You want to set some markers, what your settlement posture is going to be, what you're going to give the firm, what you're going to hold back. Are you going to give an aggregate? Are you going to give an individual? All important things. Last but not least, audit and firm expectations. The audit process can be very daunting. It can be very expensive. It is not only hard on the creditor, but hard on the firm. In a network scenario, a lot of time they can help with that. So it can also be a positive thing to have them involved if you're going through a network process, because they've been through it, they've got processes in place. We get audited for everything from court cost audits all the way through litigation audits and every place in between. Operationally, it's what's expected of us, and we know that the clients need it, and you have to decide, at what point are you going to hire an outside auditor, are you going to do it yourself, go through a network. All those things are things that must be considered. And with that, I think I've pretty much reached my time, and hopefully we gave you a little bit to think about and something to mull over as you decide what your next steps are going to be.
Okay, thank you, Michael Stillman. I'm Dave Pauken. I'm the CEO of Convoke. I'm coming to you from our offices in Arlington, Virginia, just across the river from our nation's capital. Fortunately, today we're going to talk about technology, and we're not going to talk about the new name for the Washington football team. I really have come to admire Michael Stillman and Mike DeVario for their place in the industry and their experience. I came into the industry well after these two gentlemen, but I have been involved over 10 years now, and I've got a perspective that I appreciate the opportunity to share with you today. As I listen to both of them, what strikes me is, one point that they're trying to make, and that Gary's trying to make by putting on this webinar, is that for the right accounts, a litigation strategy is an important component of your recovery if you want to maximize your collection dollars. There are some accounts that they just need to be litigated in order to collect. And in the end, you're leaving money on the table if it's just a debt sale or an agency strategy. And often the hesitancy to get involved has to do with the complexity and the risk. And I think the main message that I want to deliver to you today is that technology can be your friend to help you manage that complexity and manage that risk. And I'd just like to unpack, some of these concepts a little bit for you. When we, why is it complex? Why is it risky? Mike DeVario, Michael Stillman gave us a lot of information about that. The other element to it, though, is when you're litigating, similar to agencies, our regulatory construct here in the United States says that as a credit issuer, you're responsible for the collection activities of these third parties. You're responsible for what an agency does. You're responsible for what your law firm does. And since legal collections are more complex and there's more steps and things that you have to go through and monitor and do, therein lies the risk. And how do you effectively manage that risk and maximize your dollars? Therein lies the issue. And so over the years, Convoke has grown to be an important part of this strategy. We are not the only strategy. So I'm not here to provide an advertisement per se for Convoke, but to advertise that technology solutions can make this digestible for you. You can have a good system, a good process, and good oversight with technology, and you can your litigation strategy can flourish. It can make money. You're going to make your senior executive team happy, and you can treat your consumers with the care that I know many of you want to treat them with. So that's the main message that I want to impart to you today. What are the components of the technology solutions? Like, why are they important? And both Mike DeVario and Mike Stillman talked about a number of the things that you have to do. I've got two categories here. On the left side, it's getting information from a credit issuer to the law firm. Whether you're using a network or you've hired a law firm directly, Mr. Stillman needs information in order to pursue the collection activity. Like, he can't do it without information. He needs, there's very specific requirements, account level data. He needs the account numbers, the names, the addresses. There has to be an itemization date now under Reg F. You got to provide him the components of the balance on that itemization date, whether there's interest or fees or what have you. And then you've got to give him documentation. In a credit card, it's very common now to provide something similar to what debt buyers get. 12 statements, terms and conditions, an application, just sort of as a standard set of information when you do a placement. And as he pursues collection activity, it's very common he's going to need additional information from you. Right now, we're seeing over 160 different types of credit issuer documents end up getting to attorneys. Now, it's very uncommon that they all need to go, but it's very common that he as a law firm, he needs something additional. And you've got to have a mechanism to efficiently get that to him. Or if you cannot get it to him, he needs to know that so that he can then ask you for an affidavit or whatever the plan B is. So there's a whole process that you need to establish on getting media and this account level information to the law firm. And look, in the end, the regulator doesn't really care what the process is, right? You can send it to them by secure email, or you can send it to them over Convoke. They don't really care in the end. But if you want your financial model to make, back to the point Mr. DeVario was making, this has to make financial sense for the credit issuer. If your process for doing this is really costly, then it's going to make the whole business case harder to achieve. So account level information, media, and then there's permissions associated with this. Who gets access to the information? How do you keep this data secure? And then this element of fourth party. So if you're using a network strategy, you've got to get the information to the network, and they have to get it to the local law firm. Now, most of the networks are set up to do that. There are other solutions where if you provide it to the network, when they do the placement to the law firm gets immediate access to the media on their placement. So there's this element of another level below when you're dealing with a network strategy, and you just need to make sure your technology solution or your network can accommodate those requirements. So, okay, left side of the table there, downstream information requirements. So the law firm that you hired can actually do the job that you've hired them to do. On the right-hand side is this compliance and performance oversight. So you're after two things when you're doing legal collections. You're after, obviously, collecting the money, and that's performance. But you're also after doing it in a compliant and lawful manner. And you have to slay both of those dragons. And in order to do that, you need information from the law firm as they're performing their daily activities, as they're sending a demand letter, placing a phone call, serving a consumer, filing a complaint with the court, garnishing a wage, whatever the activity that the law firm is doing. You want to be able to have visibility and access into that. And I've seen very inefficient ways of doing that. And then there's very efficient ways of doing that. The challenge when it becomes inefficient is it becomes much harder for your local law firm to serve you well. If you're making them jump through all manner of hoops to do the oversight, at some point it becomes not cost effective for them to serve you. So you want to come up with ways for this to be an efficient process. The law firm knows you have to oversee them. They know that you want to monitor their performance, but you want to try to do that in as painless a way as possible. They've got a collection system, they've got media system, and you want to get access to that information in an efficient way, so you can monitor these things. So, for example, are they doing military scrubs in accordance with your SLA and your business standard? Did they actually serve the consumer prior to filing the lawsuit? Are they making any phone calls to consumers after 9 o'clock if they have a call strategy? Are they in a timely way pursuing the garnishment of the wages once they have a judgment? And if you get a fair amount of volume going, you can see how you need to have a system to do this. And the solution that many law firms and credit issuers use is one that we provide, so that it's pretty easy for the law firms to upload anything that changed over the last 24 hours, and we standardize that so that as a credit issuer, you can look at standardized information across all of your law firms. And also, you want to be able to easily audit all of these activities and demonstrate to yourselves, your internal compliance team, your general counsel, that you're monitoring and overseeing your law firm. And you'll also want to be able to demonstrate it to your regulator as well. Here's a picture of one approach. This is our approach, where we sort of sit in between a credit issuer and a third party on the right. And you can see these arrows going both ways. It's an efficient way to get the data and the documents to the third party, and an efficient way for the third party to get the documents and the data and audio files and texts and emails back to the credit issuer so they can do their oversight. So with that, that concludes my part of the presentation. Gary, I'll turn this over for questions. Does that make sense?
Yes, I think it does. Dave, if you start working with a client, whether it be creditor or debt buyer or whatever, do they ever lean on you about what data to send back and forth? Is that a conversation, or do they pretty much just tell you what they want to do?
Hey, they do lean on us. We have the benefit of working with, most of the major law firms in the country, and many of the major credit issuers, and so we see the types of informations that the law firm needs. We see the types of information that credit issuers want from the law firms, and we're able to provide that to the market on a no names basis. Hey, here's what other people are doing.
Right, of course.
And yeah.
It kind of segues to something I just wanted to add to what all three of you had to say. I mean, for anybody listening who's maybe contemplating this type of platform, there's a lot of resources out there, right? So you've got vendors, people like Convoke, or really any vendor outside a law firm. You have lawyers like Michael who you can talk to, and before you start your program, get feedback right on the law firm side about what you need to build this thing out. We got Mike D, who's on the consulting side, who's been on the credit issuer side. There's all kinds of people who can help you navigate this. In addition to specific companies or peoples, you also have the different associations that we all meet at and talk at, right? So NCBA, RMA, there's a bunch of commercial groups if you're on the commercial side. These different associations in our industry are valuable resources for all kinds of things, including litigation. So I encourage anybody, again, trying to gather information, to use all the resources available. Yes, Annette, the Commercial Collection Agencies of America, for sure. So we are going to I've got some questions kind of set up, and I would encourage our audience to use the chat box for any questions, and then we're going to have we'll probably have a few minutes at the end for anything else we want to add in terms of questions or discussion. So first question for you guys. Assuming a credit issuer has a nuanced recovery strategy, leveraging an agency network or selling debt, for example, what can they expect to happen to their recovery revenue by instituting a litigation strategy? Which one of you guys wants to kind of field that first?
Yeah, I'll take that one, Gary. Thank you. At least to start anyway. You know what? I talked when I was speaking about the implications going from dead sales to a litigation strategy. I mean, I think that's the most dramatic impact on revenue. As you wean down those dead sales, you're putting it into a litigation strategy that just takes more time. It takes patience. Depending upon your paper and how aggressive you are, I mean, it can take a year, it could take 18 months, it could take 2 or 3 years to get back. It just all depends. That's why I talked about the leadership knowing, how that would work out. The key there, though, is that equation, getting some smart people in a room, looking at, what you're getting from debt sales, looking at what you can project from a volume standpoint, putting together a regression and figuring out how much you're going to generate every month in that new channel until you match that, because that's going to be key. How long is it going to take? I think the other piece, when I think about if you're doing in-house collections versus moving to a litigation channel, I personally, I don't think there's going to be any comparison. You're going to see a huge lift over the long haul in putting that paper in the litigation channel. But it doesn't mean that there still isn't a place to do in-house collections. I mean, there could be some sort of hybrid approach. I think that's fairly common in the industry. The issue more there is the in-house group is what do you do with the payroll if you move away from that in-house group? And then I think with the agency, the advantage from moving from an agency to a litigation channel is so many of the processes are similar. I mean, you're already going to have a lot of the infrastructure built to move data back and forth. You're just going to have to expand that. The implication from a revenue standpoint, when you place work with an agency, you typically place it there for a very limited time. I don't know, 3 months, 4 months, 6 months, 8 months, whatever. When you place that work in the attorney channel, you're placing it for a much longer span, maybe indefinitely. So it's hard to apples to apples, but again, my opinion is that you're going to see a better performance overall in the attorney channel. But again, a hybrid approach would be completely appropriate based upon account selection.
Yeah, and hey, just to follow up quickly on Mike's comments, I think there's no question about it that the first thing you're going to see is you're going to see the revenue increase right away. Doesn't mean that you're going to see the profits increase, because as Mike indicated, and it's the reality, it's a costly startup to go into that channel. But one of the things that I've always said, right, that as a lawyer, I've always had power of the pen, right? The consumers, or whether it's a business, they know that we're kind of the last avenue of offense. I mean, the buck stops with us. We're not just going to send them a letter. We're not just going to call them. They hear from us. The next thing they're going to get is a lawsuit. All of a sudden, that brings an element of fear, an element of realism that this is no longer something you can just turn off your phone and throw away your mail. You now have to deal with it. You have to go to court or ignore court. You get a judgment against you. We end up using what's available to us through the different remedies available in the different states. And we go out there and we take the money in an involuntary basis, which, information's out there on the internet. If the consumer or the business has never been faced with this before, and in many instances they have, they can find out what's to come. And that's not something that they're going to look very forward to seeing. So.
Yeah, Gary, I'll just add some anecdotal evidence. We've had a number of credit issuers who've started a litigation channel, and we got involved to be a technology partner. And they did this over the last 5 years because after the financial crisis, a number of people stopped litigating. But starting around 2015, a number of credit issuers restarted it. And we haven't seen anybody stop. And matter of fact, they've all grown their channel. And they're doing that for a reason.
Right. That in and of itself, right? I mean, Mike, you're nodding too. Like, I don't think we have any clients that just stop litigating because it doesn't work, right? Or they're not making money. If anything, they tend to put more into the litigation channel. All right. And yeah, I think, the sort of bottom line to tie all three of you together there is that it's going to be a curve on the revenue, but overall it's going to increase the bottom line, and you just have to have the buy-in, like Mike D said, and you'll get there. Excuse me. Another question for you guys. What have been and will be the major impacts of Reg F on the legal channel in our industry? I don't think we have to review it. I think anybody who's in it knows what we're talking about. Mr. Stillman, you want to start?
Yeah, absolutely. So, Regulation F has been a huge impetus to our industry over the last 3, 4, or 5 months. I think it's going to come to an end soon, at least the issues that we're facing. And those issues truly revolve around data. I mean, that's, so we have to redo our letters, big deal. That's not a big deal. It's what data we need to be able to adhere to the requirements of Reg F. And, David talked to some of that information, and some of that data we're having difficulty getting from some of our clients, both direct creditors and or debt buyers or other clients, whether it's coming direct or through some sort of a network. Everyone is trying to get the data out, and nobody has it in a standardized way. So everybody's sending different data in different ways, and they're trying to send follow-up files to be able to supplement our data so that we have the data going forward. Some creditors have actually stalled placements because they just were not ready to be able to provide that data. It happened in a relatively short period of time that we were required to get ready for it. But overall, we're seeing it slow down as far as the impairment to us being able to get our letters out and get the data from our clients. Still not perfect. Some clients are giving us data that we're having to go back through and manually figure out how to supplement our data. Definitely not the way we want to be. We want to be able to be in a situation where our clients are giving us all the data we need at the time of placement so that everything can be automated and we can just get going, send out our initial notice and be good to go. I would say that we are light speed ahead of where we were at the very beginning in November, December, but we're still not quite over the finish line, but we're getting there.
Hey, Michael, are law firms starting to do more email or text or chat, or not yet?
I think there's a lot of talk about it.
Yeah.
I think from an industry, the lawyers tend to be a little bit more conservative than others. I think you're going to find some agencies that might be a little ahead of the curve on that. I know from our firm perspective, we are absolutely looking at it. We are absolutely investigating it. We are absolutely not doing it yet. But I would definitely see us in that position, certainly by the first quarter of 2023, if not perhaps by the last quarter of this year, to at least start to get our feet wet.
Mm-hmm. From our side of this, Gary, what we've seen some of the credit issuers ask of us is the ability to capture details around emails, chats, texts, customer contact preferences. Collection law firms and agencies, for that matter, are starting to build out these tools for digital engagement, have this information within their systems, and credit issuers want access to it. And so we're seeing that as an impact of Reg F on our side of the business.
Right. Makes sense. And there's always going to be challenges, right? We've as an industry, we've weathered various things along the way. And, Michael, like you were saying, though, you get light years better with each of these things. And I think as an industry, we're just better, right? Because compliance is a headache on some level, right? But it forces us to all do things in a better way. So it makes everything more efficient. Well, this is kind of dovetailing right off that. What kind of technology is needed to support litigation or a legal channel in 2022? Dave, you want to start that?
Well, yeah. Look, I think I've sort of talked about that, and Michael Stillman really gave some good emphasis here just now. You need a solution to get the data out of your repositories at the credit issuer to the law firm. Like, the law firm cannot pursue collections unless you give them that required Reg F data, right? It's full stop. So you need a solution to get him that data. And I think, you also, if you're going to do oversight in this new world, you need a solution to get the information from the law firm. And, okay, you can use cups and strings, or you can use something far more sophisticated, but you need to get that information in some form or fashion. I think maybe Michael Stillman's probably better qualified to talk about what his law firm might need.
Yeah, I think it's all pretty much been said, right? At the end of the day, definitely because of Reg F, we need to have data. Beyond what's needed for Reg F, I mean, I mentioned earlier, right? As a company that provides services to creditors and issuers, we're really somewhat of an information management company, right? So you've got to have a very robust infrastructure with respect to what your CRM is, your ability to be able to, withstand any sort of, elements that may come up with, redundancy. And, we put a ton of investment into IT infrastructure in 2021, and it's going to continue through 2022, and some new solutions that we're bringing on board that are going to make us better, and they're all technology related.
Yep. Again, that all makes sense. And Mike D talked in his segment a little bit about if you are already sending data back and forth to an agency, it's going to be somewhat similar, right? So you even though it's maybe not the same data or it's done differently, as an organization, it shouldn't be maybe as different as you think it is. All right, I think we got time for one more, and any other audience questions, throw it in the box real quick. We got like 3 or 4 minutes. All right, so the pandemic created some unique situations for creditors from an optics standpoint. How has it changed litigation strategies now that we're in 2022? Who wants to run with that a little bit?
So I think me. Look, I would say that right now we're almost back to normal. I mean, at the beginning, right, from an optics standpoint, you had every creditor saying, shut everything down, back off suits, back off any post-judgment activity, kill them with kindness, don't make any phone calls, don't ask any people for stimulus money. Everything under the sun was, completely back off. Slowly but surely, that's all come back. At this point in time, truly our only holdbacks are either those clients that still feel that for whatever reason, they're not pursuing some form of recoveries, whether it be lawsuits, which some are still on hold as far as lawsuits, very few, or perhaps some sort of post-judgment remedy. For a long time, actually, as a firm, we filed no bank garnishments. A lot of our clients were saying don't. With all the stimulus money, it became very difficult to try to manage. What if we got somebody's stimulus money? We just made a decision for almost 18 months or so. We did no bank garnishments. It just wasn't worth it. Other than we're back now. A good chunk of our clients, even some issuers, have started allowing us to do bank garnishments. They allowed us to do employment garnishments for a long time. That has been ongoing. But other than those, those creditor/client restrictions, really it's just state and or court. For instance, we practice in the District of Columbia. They've literally been on hold since the beginning of the pandemic, and they've made some new rules that make it very unfavorable to even consider whether we're going to continue to do business there. And then we still have some courts within each one of our different states and the other states where some courts, for whatever reason, are just slowly moving forward in the way they're doing things. So we're still seeing a lot of courts that have opened up this whole idea of keeping Zoom hearings going, which is great. Because that allows us to be able to do a lot more, quite frankly, and a lot of stupid little things. And that's the question. How do you like that? The question is, do you foresee virtual court hearings as a permanent option going forward? And absolutely, it's going to be state court judge dependent, but there are a lot of judges. And I think certainly as you look at judges who might be a little bit more youthful, who engage technology, the idea of doing virtual hearings is very encouraging, and we're seeing it continue, which is great. And it's benefited us tremendously because a lot of our clients for witnesses might be out of state, and for some hearings, they're allowed now to come in and do things virtually, which is great.
Yeah, that'll probably be the biggest positive that comes out of this whole thing, right? I mean, it just seems like something that'll help all of us. It's crazy though. Remember when the pandemic hit and the idea of debt collectors working from home, like all these things that just seemed completely impossible. Virtual court, you're going to be on. I mean, it was like there's no way we're going to function, and here we are, and it's not only did we function, it's probably all here to stay. Before I wrap it up, do any of you want to add a last comment or two? Mr. Parkin?
I'll say technology is your friend. Don't be afraid of litigation. You can make more money, you can care for your consumers, and you can be compliant.
Well said. Mr. DeVario?
Yeah, if you're going to take the road to build a litigation process, don't go it alone. Make sure you have a team and you're collaborating.
Mr. Stillman?
Just to follow up on one thing you said about, how the collectors working from home, it was really interesting. It was really the creditors that had to get on board. And, as Dave said, technology is your friend. All of these creditors had required all of their vendors, whether it was firms or networks, what have you, to have, policies and procedures in effect. If something were to happen and you had to work virtually, they all did it. And all of a sudden they're like, no. And, they had to be told, wait a second, this is what we had this for. And it's turned out to work. So, the new world is a changing world and our industry is not gone. We're still here. And there's a tremendous amount of opportunity. And I just think that if you leave litigation strategy off the table, you are definitely going to leave money on the table.
Yeah, absolutely. And just one more thing to add about the resources. I have to plug Branding Arc and Receivables Info. If you guys haven't checked out receivablesinfo.com, it's a great new website for content and information on everything involved. Thank you to the three of you. I thought this was fantastic. We get a lot of questions about, what's involved if I want to go down the litigation road. I think the three of you kind of hit it from all angles, and we really appreciate it. There will be a recording available. We'll send it to all of you guys who attended for sure, and it'll probably be on all of our websites and all that kind of stuff. So any follow-up questions, feel free to email any one of us, and we are happy to answer. With that, I think we're done. So Adam, Leah, if you guys want to cut it off, go ahead.